5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth. Now I'm talking and you just cutting me off. Do you understand how this process works?
Oh, yes. Come on, this is not slavery. I'm not the one, I am not the one. What's your likeness for?
First of all, I don't know who you think you're talking to. I don't have to answer you, and I don't answer to you. And I'm not going to start now.
From a legal perspective, this approach is highly detrimental and likely to have serious consequences. Challenging a judge's authority during an arraignment is almost always a counterproductive move and can potentially lead to contempt of court charges. It establishes an adversarial relationship from the outset. Furthermore, introducing irrelevant speeches such as those about slavery, while potentially stemming from deeply held beliefs, do not pertain to the specific charges at hand and are unlikely to aid in a legal defense. The indecisiveness regarding legal counsel is particularly critical. Facing up to 5 years, the legal system is incredibly complex, and competent legal counsel is essential to navigate it effectively. Proceeding without one or frequently changing course significantly reduces the likelihood of a positive outcome.
25S00791. FY, people say to Michigan versus Timothy Dan Smith.
Declaring on behalf of people.
Illinois, P87 446, Stephen in for the attorney of record, John Zonlin, and appearing on behalf of Mr. Dansley, who stands to my right. Mr. Dansley, can you please state the name for the record?
My name is Timothy Dansley, and I'm often represent myself and I'll take counsel as an assistant. You know, but I don't know who this being there. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer? You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork I haven't received my discovery.
Well, that's what we got lawyers for, sir.
To the count machine to get to the lawyer very well to the county. So it's paying me hard. So I'm going to need some type of system.
Okay, well, that's what we got for you. Okay.
I'm going to represent myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
Well, first I want to go ahead on with the preliminary.
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge.
I believe it's 5 years.
Yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a brain go with you.
You can have a, but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. If nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying.
That analogy is very fitting. The legal system is incredibly complex, and trying to navigate it without proper knowledge can definitely lead to consequences people don't fully anticipate.
This charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So, preliminary examination is the probable cause hearing where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. So, you understand all that? Now, you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Dan B today, and have not received any audiovisual discovery from my understanding.
I like to be honest, if you don't mind. Probably more things, you know what I'm saying, for the fact that I haven't been denied, you know what I'm saying, and it's happening, you know what I'm saying, and the prosecutor was conduct, we see a lot of discovery change, even though
okay, that's a lot of talking. Where's the prosecutor? Where's the prosecutorial misconduct?
Well, I should have had my discovery, guys.
Sir.
Yeah.
Do you understand how this process works? Well, no, you shouldn't have had your discovery because this is the first hearing.
So, you know, the first hearing, I don't prepare anything if I don't have any picture.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm supposed to just stand here and just like, oh, yes, come on, this is not slavery. I'm not the one, I am not the one. I don't care nothing about the United States. First of all,
apparently not.
Court
You must not care too much about anything, sir.
Like that for
Okay.
I have a license plate. What's your license plate?
First of all, I don't know who you think you're talking to, but do you want to spend an extra 30 days? No, you don't care. That's why you're here charged with something.
What is your license plate?
I don't have to answer you, and I don't answer to you, and I'm not going to start now. You need to settle down.
No license, must be licensed by the state.
You need to settle down. Okay, take him out of here, please. That's okay. He's just having his moments.
It sounds like you're analyzing a situation where a defendant's unconventional approach clashes with the structured nature of the legal process. The commentary highlights the tension between addressing specific charges and attempting to use a courtroom as a platform for broader societal critique.
So we're going to adjourn this, and I'm going to waive the 21-day, 7-day rule for this discovery. Welcome to Friday. All right. So we'll give you, what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give like a couple weeks to do it.
Yes.
And he's going to want to see it. So you're probably going to need to have him take a laptop over there to the jail and take his license to practice law to him. Okay. All right. So the next probable cause conference on this charge is going to be.
All right, I just to make a record as regards to that discovery. I do have paper discovery, which Sister Counsel has noted that has been attended already. I do not have. Does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on
Court's available August 25th at 9:30.
August 25th at 9:30. And hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Dominic will be in trial in the Wayne County Circuit Court. I make that paperwork for myself, but if you're wanting Mr. Dominic to be here,
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance, I would be more comfortable if Mr. Dominic has handled his own.
Well, you know what? You got to cut your teeth somehow. We've all had this.
Just don't.
Ask Miss Gracie. Okay. Ask Mr. Puda. We've all dealt with difficult clients.
We got this Gracie right. He's an expert in this.
I've had my share over the years when I was licensed to practice law. So by his standards, I'm not licensed. Okay. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Gonick visit him and talk to him, and hopefully he'll be a little more settled down. Okay, that concludes that matter.
That scenario definitely highlights the serious risks of self-representation, especially in felony cases. The legal system can be incredibly complex, and misunderstanding your rights can have profound consequences, just as you described. It's a gamble with very high stakes.